Started. My name is Stephanie Charles. I'm a Cleary Gottlieb Legal Fellow at Start Small, Think Big. I'm very thrilled to be here today and to be joined by my colleagues, Elizabeth and Christina, for this presentation on understanding contracts and contracts issues, particularly in light of COVID-19 today. So what we plan to do today, we'll start off with a brief introduction to Start Small, Think Big, and talk to you about our services and what we do to help small businesses with their legal, financial, and marketing needs. We'll then move on to a presentation on elements and key points of a contract, followed by breach, remedy, and enforcement issues in contract, followed then by changes to or termination of contracts, looking at legal tools available for these changes, and really stressing and finishing up with tips and strategies and practical considerations in contract negotiation. Before we start off, note that this presentation is current as of today, July 30th, 2020. The contents of the presentation and the topics we'll talk about today are by no means comprehensive. They are not and should not be construed as legal or tax advice, and certainly should not substitute for consultation with an attorney or an accountant. These materials are really for educational purpose only. The presentation is proprietary. It cannot be recorded, photographed, or reproduced or otherwise distributed without our prior written consent at Start Small, Think Big. With that, I'll pass it along to Liz, who will get us started with an introduction to Start Small, Think Big.
Hi, thank you so much, Stephanie. Welcome to everyone who's viewing this presentation and to those who will be viewing the recording later on. We're so thankful that you've taken some time to come and listen to us today and talk with us today about contracts and negotiation, some of my favorite subjects. Before we get started, I want to give a brief introduction to Start Small, Think Big as an organization. If I could have the next slide, please. Start Small, Think Big is a 501c3 nonprofit organization that provides free services to small businesses and entrepreneurs across three areas: legal, financial, and marketing assistance. We believe that by providing this assistance to entrepreneurs and small business owners, we can help to increase personal financial stability for you and your household, and also uplift communities and help with economic development. We primarily serve under-resourced small business owners and those in traditionally underserved communities. The next slide, please. Let me give you a breakdown of our services. Our legal services focus on transactional or business legal services. This means that we can do everything from helping you to set up your business entity, like an LLC or corporation if you haven't yet done so, and thinking through template contracts to use in your day-to-day business transactions, to other topics like considering how to protect yourself legally while doing business online, employment, intellectual property, commercial leasing, and drafting and negotiating more extensive contracts like those we'll talk about today. Our business and financial assistance focuses on helping you ensure that your business bookkeeping and other elements of your business's financial planning and business planning are on track to help you grow and succeed as a business. This might mean everything from starting up your business bank account and getting on bookkeeping for the first time, to cleaning up your books and building some financial projections that'll help you as you think about topics like we'll discuss today, contracts and negotiation. The finance team can also help you consider investments, equity, loan and grant options, and think through things like valuing your company. Finally, our marketing division works with you to develop marketing and sales strategies and teaches about e-commerce, online advertising, SEO, building websites, building a brand identity so that you can continue to engage and connect with your customers, and improving your client engagement online. The next slide, please. Start Small, Think Big has a lot of resources that are free and available to anyone. We offer a lot of free classes and workshops that you can view on our website at startsmallthinkbig.org. Links to programming is also available there. You can see some of the businesses we serve on our Shop Our Businesses page. If you decide to request free services with Start Small, Think Big, we bring on clients for 12 months at a time and provide 12 months of ongoing services. You can reapply as often as you're eligible. And again, all of our services are free. The next page, please. A lot of businesses are interested in finding out our eligibility criteria. So we have a few things. One is that eligible businesses must be currently operating businesses. If you have a business idea and you're not quite there yet, we're excited for you to come on board when you do have at least $500 in sales within the last 3 months. If your sales have dropped because of the COVID-19 crisis, we are considering evidence of sales prior to that crisis. So if your sales have dropped off, but you had sales back in January, February, March, then you can feel free to reach out to our team and submit an application. And then finally, no more than 1 million in business revenue over the previous 12 months, because we are here to help under-resourced entrepreneurs and business owners. Our other guidelines are that household income is generally at less than 500% of the federal poverty guideline, and household assets, excluding your retirement account, house, and first car, less than $50,000. We're really focused on serving entrepreneurs who are traditionally under-resourced. The next slide, please. And if you have questions about whether or not you're eligible, please reach out and email us at hello@startsmallthinkbig.org. One of our legal fellows for the summer, Christina, is typing that email address into the chat at this moment, so you can find it there. And again, that's hello@startsmallthinkbig.org. Feel free to reach out if you have any questions about eligibility. A lot of businesses have questions about COVID-19, and Start Small, Think Big has a very robust response. So our legal program is offering webinars, written materials, and consultations. You can find a lot of information online on our website in our COVID-19 hub, which you can find by visiting our website, startsmallthinkbig.org. We have information there about PPP and EIDL, really important information about how to apply for those forgiveness programs, and information about contracts, debt management, doing business online, labor and employment, reopening, and other issues that you might have. Our business and financial team is also offering webinars and one-to-one assistance, as well as our marketing team is offering weekly sessions, one-to-one assistance, and help developing free websites. So do reach out if you have questions about those things. The next slide, please. Finally, our COVID-19 Rapid Response Program is available to anyone who has a small business or an entrepreneur, regardless of whether or not you meet our eligibility criteria. The main criteria here is that you do need to actually be operating a business, but the COVID-19 Rapid Response Project is free. We provide free COVID-19 consults on legal issues that you might have. Our financial team is offering consults to that program, and our marketing team as well. It's a really fast and easy form to fill out. It only takes about 2 minutes. You can fill it out while you're listening to this webinar. The link is here. That's covid19.startsmallthinkbig.org/request. It is also available in Spanish. If you'd prefer to view the form in Spanish, simply click on the form and select the Spanish option. And Christina is pasting that link into the chat at this moment to make it really easy for you to access. And again, we have our COVID-19 online resource hub, which has lots of great information and is being regularly updated. So do check there regularly. The next slide, please. With that, I'd like to turn things over to my colleague, Stephanie Charles.
Great. Thank you so much, Liz, for this introduction. As we mentioned, we will spend a great deal of time during this presentation talking about negotiation strategy, negotiation tactics. Before we do that, though, we do want to spend a few minutes discussing what it is that we hope that you as small business owners will be negotiating, and that's contracts. Now, some folks who are either here with us today for this webinar or listening to the webinar later on might have entered into hundreds of contracts. For other people who are at more initial stages of their business, they might be a little less familiar with topics of contract law, particularly relevant to small businesses. So we'll start off with fundamentals, and what I want to do here is really discuss some of the basic elements and key provisions of a contract, just to ensure that we're all on the same page and really help equip everyone with the required, the necessary vocabulary to really enter into these discussions and understand their contract and contract issues.
Stephanie.
Yes.
I'm sorry, this is Elaine from SBA. I needed to have said something at the very beginning. I do apologize. I was trying to get in and I was having some difficulties. So can you pause for a quick second before you get into your PowerPoint?
Absolutely. I will pause here and I will let you introduce you and the SBA.
Okay, my name is Elaine Powell-Bell-Navis. I'm so sorry. I'm from the SBA. We, together with the Start Small, Think Big and the Business Outreach Center in Brooklyn, have joint ventured together to bring this workshop to you this afternoon. We are hoping that you're going to take full advantage of this. The SBA is a federal agency and we're located in all states. There's about 104 of us nationwide. And right now we are trying to, if there's anyone on the phone that is interested in getting the PPP loan, which is the Paycheck Protection Program loan, or the EIDL, which is the Economic Injury Disaster Loan, you need to get in contact with the Business Outreach Center. I think Start Small, Think Big say that they have something on their website concerning this also. But the deadline for the PPP is August the 8th. I do not think that they will be extending this from August the 8th. So if you are in need of finances, and the PPP is for payroll and expenses during COVID-19. If your business was affected by COVID-19, then the SBA has what they call the Paycheck Protection Program, which is a loan. It's on their website. Our website is www.sba.gov. You can go on, and all of the information that I'm telling you is on the website, but you have a short span of time to fill out that application. All banks or participants in this program, you can find that out. We have what they call fintech companies, which is PayPal, Cabbage. We have all of those that are participating in the program. They'll assist you in filling out this application and filing it with the appropriate financial institution. There are 24,000 financial institutions across this country that are participants in this program. This particular loan must go through the bank because it is the bank that's actually making the loan to you. It is a forgivable loan, meaning if you use it for payroll and expenses, you can file for forgiveness and it becomes a grant. So if you've not heard about this PPP, you really need to get working on this PPP. There's $130 billion still in this fund. So I just want you to know that if you want to, feel free to put that application in before August the 8th. Don't even wait till the 8th. Try to get it in by August the 5th. That will be a better time to do it for you. And the EIDL, the expiration date on that is December the 31st. So that's why I'm telling you the PPP is kind of crucial, is something that you should be doing right now. And that's like the hot thing that's going on right now. Of course, we also have similar services to help people out at the Small Business Administration. I am going to put my information in the chat. And I think that if Elizabeth is going to be sending this out to you, that you can get that information from the chat. But I just want you to know about the PPP. Is very important to me, that the $130 billion is not just sitting there when it could be doing something to help you stay in business. That is what we are here for. The SBA is to make sure that small businesses survive COVID-19. So I'm so sorry that I had to stop and get in here to say that to you, but I was having some difficulties getting into my computer. So I'm going to turn you back over to, it's not Elizabeth, it was someone else. I don't know. I hope she's still there. Elizabeth?
Thank you, Elaine.
Okay, Stephanie. Okay, I'm going to turn it back over to Stephanie. I apologize again to everybody that was on the phone, but I just wanted them to know about the PPP. I saw that Elizabeth put something down there, but the Women's Business Center also does the same thing, but we're going to have that information in the chat. Okay, thank you.
Great. Thank you so much for this very important information. So to turn back now to our discussion of contracts, I will get us started with basics and fundamentals in contract and contract law. First of all, what is a contract? It's essentially an agreement between two or more parties that creates obligations that are enforceable by law. What does that mean, and what would you expect to see in a valid contract? You'd have an offer that's clearly and adequately communicating essential key terms of a proposed transaction, acceptance of that offer without changing the terms of the offer, and consideration, i.e. an exchange of something of value between the parties that are entering into the contract. What does it look like? Typically, we think of contracts as being in writing. We certainly recommend that, particularly in the small business sphere, folks enter into written contracts. That said, it's not a requirement that a contract be in writing in order for it to be enforceable. A contract might be entirely or in part verbal. Note, though, that certain contracts by law are required to be in writing. Oftentimes, these requirements will be jurisdiction specific. In New York, for example, a contract for the sale of goods for over $500 has to be documented in writing and meet other requirements in order to comply with what's usually what is referred to as the statute of frauds. Now, with those fundamentals said, why enter into a contract? The goal really is to minimize ambiguity, confusion, disagreement, and promote clarity. As business owners, you want to set out and memorialize expectations for yourself and for your counterparties in a way that is clear and that allows you to manage your risk as a business owner. And finally, you want to have something in place that really provides a clear path forward in case things go wrong. With that said, what are some key contractual provisions that you might want to see, or that you might typically see in a contract that you negotiate? I've included them here on the slide. Again, the goal here is not at all for this presentation to be comprehensive or to turn you into contract lawyers. It's always better practice to work with an attorney as you review, negotiate, and contemplate entering into contracts. We hope, though, that with the slide in this presentation, you'd have some fundamental understanding of some of the vocabulary that really allows you to better understand your contracts and better have those discussions with your attorneys. A few provisions that I do want to highlight here in light of COVID-19, provisions that are particularly relevant in the climate of uncertainty today, and as we see more and more individuals and small businesses facing financial distress. Things like termination provisions. Does your contract have a clause in there that describes how you can go about terminating early the contract? What are the consequences of doing so? Is there a penalty or a fee? How do you go about giving notice that you intend to terminate a contract? Those are things that would typically be set out in a termination clause of a contract. Amendments of a contract. Say you do have a contract in place, but you want to maintain it in place, but you want to modify certain terms that have already been negotiated and included in the contract. What does it say in terms of how you can go about amending your contract? Who is authorized to change the contract? What are the signature requirements for amending a contract? Again, what is the notice requirement for going about and amending a contract that exists? If there is a dispute around a contract, is there a provision that says that you have to necessarily go through mediation or arbitration in order to resolve that dispute? Is there something in the contract that says that even though you are located in New York, your counterparty is in New York, the governing law of the contract is in fact Delaware law? Those are key provisions that you would typically expect to see in a contract, and as I say, have become especially relevant today in this climate as businesses are finding it more and more important to negotiate or renegotiate, in fact, contracts that they have entered into in light of COVID-19. Now, it becomes important, of course, to ensure that those provisions are properly drafted. As you review contracts, or in fact, as you contemplate entering into contract and sign them, oftentimes contract issues, drafting issues might not be clearly identifiable from the jump, but in fact, only noticeable when a problem comes up. You might then realize that your termination provision was not drafted clearly enough or was incomplete. You might find that there is a lack of clarity and the description of the obligations that you or your counterparties are entering into. You might find that a contract that should have been signed by your business entity, a corporation or an LLC, was in fact signed by yourself as an individual in your personal capacity. Those are types of issues that we encounter in contract drafting and that attorneys certainly try to prevent and control for, which again is why we would stress that as you contemplate entering into contracts or find yourself negotiating or renegotiating contracts, that you try to have an attorney to help you out throughout that process. Now, with that said, things sometimes do go wrong, even when contracts are properly drafted, but especially when there are errors in drafting. In this context, as mentioned, in light of financial distress that individuals and businesses are finding themselves into, issues of breach of contract become especially relevant. Breach, remedies, and enforcement of contracts. So I want to spend a couple of minutes talking about those. Again, so we're all on the same page, at a basic level, a contract breach is a failure to perform all or parts of the obligations that are set out in the contract and the way that it's been agreed upon in the contract without an available legal excuse for the breaching party to performance under the terms of the contract. Now, some examples of breaches I'm sure we're all very familiar with, and we can clearly identify. A party enters into a contract to deliver a good to another party who in turn accepts to pay a certain sum of money, non-payment of that sum or payment of an amount that is lower than what's been agreed upon, failure to deliver the good or the service or deliver it in the manner that's been in the condition that's been agreed upon in the contract, delays, missed deadlines, violations of provisions such as confidentiality provisions. These are all examples of contract breaches. What happens when when folks find themselves in these situations, typically the non-breaching person might be entitled to no longer have to perform their end of the bargain and their obligations under the contract, and they might be entitled to seek legal remedies with the court in seeking enforcement of the contract. Now, when it comes to our discussion of breaches and remedies, again, drafting remains extremely important. The language of the contract itself might provide indications that are that impact and indicative of what constitutes a breach, what are the types of remedies that are available to a party. For example, is there a provision in the contract that says that even if a party fails to perform or is delayed in performing its obligations, that they have 3 days, 5 days, a certain period of time to rectify that breach and comply with their obligations, what in legal terms is referred to as a cure period. Are there built-in mechanisms in the contract that really anticipate the event of a breach and try to incentivize parties to perform under the terms of their contract? For example, if the issue is payment of a certain sum of money, is there a provision in the contract that says that if there is a delay in paying that amount, that there is a default interest, an additional interest that starts to accrue and penalizes really the person who is not complying with their obligation until that amount is paid? Again, these are drafting considerations that touch on this question of contract breach and also contract remedies. Now, what do I mean by remedies and remedies for contract breaches? Typically, I'm referring here to money damages. It could be in the form of penalties. So as I mentioned just now, interest on late payments. It could also be in the form of specific performance. Now, this is very rare. And by that, I mean the obligating a party that's taken on a contractual obligation to perform under the terms of the contract and fulfill its obligation. That's very rare and typically only available in a case where money damages really can't compensate the other party that's entered into the contract. But again, as you're building your vocabulary around these issues, you might come across this question of specific performance. Now, I want to spend just a minute on money damages and particularly how they are calculated and how a court looks to money damages and considers those damages when there's been a contract breach. Some key terms here: expectation damages. The goal there is really to protect the party that has not breached its obligations under the contract to realize the expected value that they had in entering into that contract. Reliance damages instead seeks to compensate a non-breaching party for any economic injury that they might have incurred as a result of the contract breach. Restitution instead, the idea here is to make the non-breaching party whole and avoid any benefits that a person that's breached a contract might end up obtaining as a result of their breach, which would really be thought of as unjust enrichment. And I mention these just to highlight the fact that when we're talking about money damages here, the goal for a court is not to penalize, it's not to punish, it is much more compensatory, it is to compensate a party that has been harmed. And that's the lens through which a court would be viewing, looking at, and considering money damages and calculating money damages in the event of a breach. Now, in order to get to this moment of collecting damages and remedies under a contract, what a non-breaching party would be seeking is enforcement of that contract. What we want to highlight is that there's a number of considerations beyond just legal considerations that come to play when it comes to how a non-breaching party goes about enforcing a contract, and in fact, whether they seek their legal avenues and enforcing their contract. Why might that be? It's basically because enforcing a contract and going through the litigation process and seeking relief from a court, that's all very expensive. It's expensive financially in terms of amounts that have to be paid to secure all of that. It's expensive too in terms of time. It's not atypical for litigation to take on years. And if you're running a small business, it might be years that you really don't have and don't want to spend tied in litigation. The other issue is that even where it seems that the dispute is a clear win, there's always an element of uncertainty. It's very hard to predict what happens at the end of a dispute, even when you take matters to court and you believe the law to be on your side. And there's also the question of collecting on a judgment. Say you do go to court and you do seek enforcement of a contract and you actually do obtain a favorable judgment that allows you to collect your remedies from your counterparty. Is that counterparty in a position to pay and to compensate you as has been ordered by a court? You might have a judgment, a valid judgment that you can wave around, but again, particularly today in light of COVID-19 and just the general climate of uncertainty and financial distress that we find ourselves in, it makes the prospect of collecting on a judgment very uncertain and hard to predict. Other practical considerations, insurance coverage. Do you or your counterparty have insurance as a business owner and as you enter into that contract that would allow an insurance company to cover part of the damages that are incurred as a result of a contract breach? This becomes relevant because it really should inform your strategy in terms of what you pursue in seeking enforcement of a contract, but also informs the discussions that might be involved, the negotiations that might be involved where there has been a contract breach, and as the parties are contemplating and assessing the various routes that they have available in seeking enforcement or not of their contract. The key takeaway here is that when you've entered into a contract, if there has been a contractual breach, the next logical step is not necessarily litigation. Oftentimes, you might actually want to contemplate out-of-court options, and that involves a great deal of negotiation, obviously, with your counterparty, which is why we really want to stress these tips and tactics and strategies and negotiating and renegotiating as you find yourselves in the position to enter into contracts and think about the contracts that you currently have entered into. Now, the next thing that I want to talk about before we get to these practical considerations in contract negotiation is to help you think through what exactly it is that you might seek to renegotiate as you enter into a contract, and the types of changes that you might try to avail yourself of, even if you have existing contracts in place. I've talked a little bit about why you might want to go down that route. Again, given the hurdles involved with and associated with going down the litigation route, it's often very helpful to at least consider in the first instance what you can negotiate with the counterparty where there has been a breach of contract or where you expect that it is likely that there might be a contractual breach. In terms of steps that you want to take as you approach that process, obviously you want to know your contract. You want to know what are the obligations that are at play and understand where the risks and non-compliance lie. You want to try to anticipate what your counterparty's responses might be if you try to seek a contractual change to better align with your circumstances. You'll want to carefully review the relevant contractual provisions, particularly as they relate to amendments or termination. And you'll want to have a sense of what kinds of mitigation strategies you want to discuss with your counterparty in the event of a contractual breach. In terms of legal tools available to folks who are seeking those kinds of changes in their contractual obligations, I mentioned already the question of amendment. The idea here is if you already have a contract in place, you want to maintain that contract in place, but given your counterparty's changed circumstances, you want to seek certain changes in the terms of your existing contract, you can negotiate with your counterparty to try to reach an amendment to the contract that better suits your and the counterparty's needs. It might be the case, moving on to the second point here of termination, that in fact you do not want to maintain that contract in place at all. And it would be more beneficial for you to actually try to exit out of those contractual obligations altogether, or it might be an outcome that your counterparty seeks. Their termination provisions, as mentioned, will be very helpful in terms of thinking about the mechanics and legal steps associated with seeking that termination of a contract, and also will be helpful to help you weigh the pros and cons of whether or not it is in fact more beneficial for you to terminate that contract or allow your counterparty to terminate their contractual, terminate a contract and exit out of their contractual obligations. You might also find that a contract has certain provisions baked in that contemplate the situation similar to where we are today, where because of events really outside of a party's control, e.g. a pandemic that swept across the globe, that they are no longer able to perform their obligations under the contract. And that's where force majeure, which is a type of, that's the language really for that type of clause, comes into play. I'll talk about it very briefly in the next slides. I will flag already, it's extremely rare and very difficult for parties to avail themselves of these kinds of provisions. You'll see that New York courts in particular, they read those provisions very, very, very literally and closely. So it is difficult to find relief there, but it is an option. If you're entering into a new contract and would not, ordinarily have thought about trying to include a force majeure clause there, given the context that we're in today, that might be something that you, and again, hopefully your attorney, talk through and think through as you enter into those negotiations. Quick point on the last couple of bullets on the slide here, and possibility and frustration of purpose. What I want to highlight here is that even when there's not a clear path forward, for example, a clear termination clause or a force majeure clause in a contract, and if matters do actually end up going to court, there are other legal principles and doctrines that a court might look to in determining whether a party can exit out of a contract, impossibility and frustration of purpose being one of those. But again, this is really if matters cannot be resolved between parties and actually do end up in litigation. So as mentioned, just a couple of quick minutes on force majeure, what it is and what it does. It's of heightened relevance in our present context, as mentioned, because more and more people are looking to their contracts right now and trying to figure out if they include a force majeure clause that offers some level of protection in the event that something completely unexpected, completely outside of their control makes it impossible for them to enter into, to fulfill their obligations under a contract. I've put here on the slide just a quick example of what this provision might look like. I highlighted in bold some language that describes the types of events that might be included in a force majeure clause. You'll see here that this includes, a viral base a viral pandemic, for example, might be included in a force majeure clause. It might not. The point, though, is that courts typically, and again, particularly in New York, they would look strictly to the contract itself, the clause, the words, and the items that are listed out here to determine whether or not a party can actually make use of the force majeure clause, which makes it very difficult, again, as a tool to sort of negotiate yourself out of obligations under a contract. But just for sake of completeness, if you had a contract and you were contemplating whether or not you could avail yourself or your counterparty could avail themselves of a force majeure clause, a few questions that you would ask yourself: first of all, you'd want to make sure that the contract actually does include such a clause. If not, it's just not going to be an option that a court would offer up. You want to look at if the specific events that are at play, so again, in our context, COVID-19, whether those might trigger your force majeure clause and be covered under what's listed in the force majeure provision. You'll want to consider what is the standard of performance that's required to trigger the force majeure clause. That is to say, you'll want to consider whether the provision says that, it would have to be that these events that are included here make it impossible, not just difficult, not just unfortunate, not just very burdensome, but in fact, absolutely impossible for you to comply with your obligation for a party to avail themselves of a force majeure clause. All of this would have to be documented in the contract and in the clause for it to make sense as an option for a party assessing its options there. And finally, you'll want to consider what are other requirements, for example, notice requirements. Who do you have to tell? And with how many days in advance would you have to tell a counterparty, or would a counterparty have to tell you that they intend to use and invoke a force majeure clause to exit out of their obligations under a contract for them to be able to do so? So again, very difficult, but it is a tool that we're seeing folks look to more and more as they review their contracts or negotiate new contracts or try to renegotiate existing contracts. The point here is really that there's a lot of room for folks to negotiate, think about their circumstances, and try to arrive at mutually beneficial outcomes for themselves and their counterparties in the context of contract and contract negotiating. So with that, I want to pass it along to Liz, who will come and talk to us a little bit more about some of these tools and strategies and practical considerations when you're looking at negotiating new contracts or, in fact, renegotiating existing agreements that you might have.
Amazing. Thank you, Stephanie. Before we jump into the practical considerations for negotiation, I just want to give time for a couple of questions that we got about the legal aspects of contracts.
So we had a question from Maria, and she wanted to know if signing a contract virtually, meaning through an e-document sign, is that as good as signing in person?
Sure, that's definitely possible and doable. Sometimes you might see contracts that actually explicitly allow for e-signature, particularly today in light of COVID-19. You might see contracts that explain that in addition to being signed by the person entering into the contract, they have to be notarized as well. So it really depends on your particular circumstances. There's nothing inherently wrong with e-signing of a contract. Oftentimes it will be a matter of just making sure that you're on the same page with your counterparty and making sure that there's nothing in your contract that explicitly says that it has to be signed in person, it has to be notarized, or anything along those lines. There's room for negotiation there. It's a matter of making sure that you're on the same page with your counterparties.
Thank you. All right, so let's turn our attention then to practical considerations for contract negotiation. I want you to take a second and type into the chat the first word that you think of when you think about how you feel about negotiating. I'm gonna give you a minute to do it. And I want you to just go ahead and type that into the chat. The first word that comes to mind when you think about negotiating or having to negotiate something. Next slide, please. All right, I see a couple of answers coming in. A lot of the answers are nervous, scary, win, lose, research. You know, there's a lot of people, you know, on here who are typing nervous or scary. And it's interesting because a lot of people really, really hate negotiating, but they find it really a fearful thing to have to do. You know, if you watch TV, you'll get the impression that negotiation is where two people come in and slam the table and slam doors and stomp their feet and yell at each other and try to beat the other into, you know, to winning the negotiation. And today I want to talk to you a little bit about negotiation. And I want to emphasize that, you know, that model of negotiation, the win-lose model of negotiation, is A, not a real model, B, and not a good model, and C, not the model you should be pursuing or the mindset that you should have as you're walking into a negotiation. So what even is a negotiation? It's really just two people or more people coming together to work out a solution to a mutual issue. So if you think about your day-to-day life, you probably negotiate all the time. During this COVID situation, I don't know about you, but I've watched some movies. And certainly when I'm with a group of friends or family, there's some debate about which movie we should watch. Some people prefer a romantic comedy and others prefer a sci-fi movie or an action film or an international film. And in that situation, we're actually having a negotiation. We're reaching an interest about, you know, what movie we're actually going to watch. And the reason I really like the analogy about friends watching a movie together is that in that situation, the movie is sort of important, but it's not the main thing. The main thing in that situation is our relationship as a group of friends or as a family. And if we battle it out, you know, to try to choose a movie that no one else wants to watch, and we battle it out, then it damages our whole relationship. And that's really something to think about when you're talking about negotiation. For most negotiations that you're entering into in your business capacity, the negotiation itself is important, but the business relationship is often just as or even more important because you'll likely have to keep on doing business with that person. And going into the negotiation with a win-win mindset can help you to reach an outcome that actually works for both parties and that will facilitate an ongoing relationship. Because when people have a really bad contract or they walk away, there's a greater chance that the deal is going to fall apart or that they're going to breach later on, or you'll have to breach later on and be in some of the situations that Stephanie has discussed. The next slide, please. So I also want you to encourage you to think about situations in which you can negotiate and to approach every business deal as a situation for negotiation where things are up for discussion. So even if someone, you know, hands you a standard contract, or even and says this is just what we do, you know, there's probably still some room for negotiation or discussing the terms. Even if the other party is a big player, maybe they have a lot more leverage, maybe you're in a lot worse of a position than they are in and they know it, you still have some room to discuss options that are win-win for everyone. So how do you prepare for a negotiation? I want you to type into the chat now the first thing that you do when you're preparing for a negotiation. So I see an answer, research, some other answers coming in. A competitor analysis, that's a good answer. Yeah, what else do you do? Market research. Yeah, so a lot of answers, thinking positive. I think that's actually really a great strategy to start your preparation for a negotiation with. Thinking about what you bring to the table and what your value is. Yeah, these are all great answers. Keep typing answers in. So let's walk through this a little bit. The first thing to do is often to determine market comparables, to do market research, as a lot of you have suggested. So think about what other companies are providing similar goods or services, what their prices are, and other elements that might be relevant to your transaction. So for example, if you're working on, you're gonna bid for a government contract, or if you're gonna talk to a school about possibly providing consultation services, or to a company about providing graphic design services, or if you're a food company and you're talking about catering service, look at who else is in your range in the market and see what they're offering and what their products look like, what their pricing looks like, and think about how you're positioned relative to them. What elements does your company offer that their company doesn't offer? What value add do you have? What are they offering that you're not offering? It's good to be aware of all of the pieces. If you need some help learning how to do market research, the Brooklyn Library offers this service, and the Rochester Library offers a free service where they'll provide market research for you for free. So the Brooklyn Library will teach you how to do market research, which is awesome. But in a pinch, the Rochester Public Library, even to people who aren't in Rochester, who are down in New York, other parts of the state, will provide free market research services for you through their Business Insight Center, which you can find on their website. So that's really important to know. So the second thing to do is to identify your BATNA, which means the best alternative to a negotiated agreement. So what this really means is, what is my option if I walk away, and what is their option if we walk away from the table? So for them, it might mean going with a different catering company than yours. For you, it might mean going out and doing more farmers markets, or it might mean, going with another company, offering your service somewhere else, or choosing a different option. So think about what your other options are, and try to think about what the other company's options are. In some cases, they may have a good option or they may not. So it's important to kind of be aware of that, because at the point where you reach your BATNA, where the deal on the table is no longer as good as other options that you have, then you've hit your walkaway point. And it's really important to be aware of where that point is. So you want to identify any deal terms, deal points, or breaking points for you. So financial terms. To identify your financial terms, this will mean that you'll have to have some sense of your cash flow and your financial projections for your company. What are your expenses? What is your revenue? At what point, what does this deal need to look like to be profitable for you and to help push your company in the right direction? If that's something you haven't done yet to get financial projections in order or financial statements in order, definitely reach out to Start Small, Think Big. That's one of the services that we offer for free to our clients, is to work with our finance team and to think about bookkeeping, financial statements, and projections so you can be prepared when you go into these negotiations. Think about the term of the contract or lease or agreement. How long should the relationship be? Should it have an automatic renewal? Should it have points to renegotiate? Think about what you want the relationship to look like long term. Think about how much time you need for completion in the best situation and in the worst situation. So try to think through things that might go wrong. Like, what if a supplier is a little bit late delivering something? And try to build that into your deal. Think about investment terms, about how much money everyone is putting into the situation, what other types of investments you might have to make. So if you're agreeing to provide, kombucha to a retailer on a really large volume, will you need to go and get additional space? Will you need to invest in supplies? Do you have enough working capital to do so? So think through the financial aspects that aren't exactly in the deal, but that are more indirect, and any other terms depending on the situation. And then finally, think about your walkaway position, based on your BATNA and your deal points. At what point would the deal not be profitable for you? At what point does it not fit your business's strategy? And a big point in this can honestly be having financial projections. So it really helps before you go into a negotiation, if you can have financial projections to show, to basically plug into an Excel or another type of sheet, what, terms are being offered and what the end result is going to be for you. And see when it's not enough, because even, a few cents can honestly make a huge difference. The next slide, please. So there are some strategies that you might employ for negotiation. So first is sort of building a roadmap. So a roadmap is basically where you're going to lay out what's going to happen in the conversation, like Stephanie did at the beginning of our conversation with you today. So the first thing that you'll often want to do is build momentum. So that might mean reaching agreement on some easy points when you sit down with someone. So maybe you have some small talk, maybe establish a comfortable setting, and then perhaps you're agreeing on a few things that are easy and that you both clearly agree on. It's often good to address the most important points under contention next and make clear which parts of the offer you want to discuss. So a lot of times before a negotiation, there's often some writing or some conversation. You may have emailed back and forth with someone. Maybe a problem's arisen and you both kind of discussed it. Maybe the other side has made you an offer. Maybe you've made them an offer. So start by talking about the points under contention. What parts of the offer is it that you would like to discuss? And it's pretty important not to be unclear about that or vague, because the other party, in most situations needs to know, what's on the table, what you're actually trying to discuss. But that being said, don't be afraid to defer discussion of a top issue until later. So you don't want a particular issue to railroad the conversation. So if you're discussing something, for example, price that isn't really panning out and you're having a lot of back and forth, open up the table to other topics and discuss some of those so you can continue to make progress. And often by opening up the table to other items of discussion, you'll be able to find some agreement and reach a consensus on the other points that are harder. And finally, it's usually a good idea not to nitpick the offer at the beginning. So sitting down at the table and saying, well, this is wrong with your offer, and this is wrong with your offer, and this small thing is wrong, and all of that can often be really discouraging and set a bad tone to negotiation. So save the less important things for later. The next slide, please. So talking a little bit more about strategies, think about how you're going to negotiate the financial terms. So one thing that's really important is to avoid the use of anchors as reference points. So by an anchor, I mean, often a number that gets thrown down. So a lot of times one party will throw out a number at the beginning of the negotiation, or they'll throw it down in an offer. And it may or may not have any relevance to the negotiation. It may be close or far away from their maximum or minimum. It may be, it may be a good offer. It may not be. But don't allow their offer to sort of anchor or frame the way that you discuss things. Know where you want to come out before you make a counter offer. So a lot of people sort of have this tendency in negotiation. For example, if you're negotiating the purchase of a used car, people have a tendency to say, oh, the price is $10,000, so I'll offer 6 and we'll come out at 8. Try to know where you actually want to come out before making a counter offer, and don't just offer, something that kind of sounds reasonable that may or may not be where you want to actually come out, and think about the whole options that are on the table. So don't increase or decrease your offer until the other side has countered, or you just end up bargaining against yourself. This is really common. I like to travel sometimes, and if you go to a market, sometimes in other countries, I like to watch tourists, because they find someone to negotiate with, right? Like, they say they want to buy like a sweatshirt that says I love Rome or something ridiculous like that. And the person who's doing the bargaining, the seller will say something like, oh, that's 30 euro. And the tourist thinks they're going to negotiate. So they'll say, oh, I'll pay you 20. And the seller doesn't even say anything. They kind of make this expression and go like this. And the person goes, well, okay, 25. And they just negotiated against themselves. So don't do that. Wait till the other side actually responds or counter offers, and assume that there will be several rounds of offers and counter offering. It's very much a back and forth, and try to feel okay with that, just the same way that you would negotiate over what film to watch with your friends or with a family event. Workouts. So a workout is when you already have a contract and you're trying to find a revision to the deal. You're trying to make a new agreement that'll work. And right now, a lot of people during COVID are doing that right now. They're trying to make up deals, especially around leases or contracts that aren't going to work out, where people have a lot of problems and are trying to find a deal or a workout that's going to work. So the contract will remain binding in that situation, but both parties are agreeing to modify it. So you're communicating that request, and you're trying to find a solution that benefits both of you. Because in many cases, you'll both be better off with a revised deal than one that isn't performing. Your landlord might be very well be happier to have you pay half the rent for a period of time and make it up later, or waive some of the rent if you continue to operate your business and use that space, than to have you default on the loan altogether, or on the lease altogether. So remember that sometimes the party would rather have a revised deal. The next slide, please. So finally, we're going to talk a little bit about concessions. So something to remember about concessions, and by concessions, I mean something that you offer to the other side, something that you give up, essentially. So make sure that you offer things that you can actually live with, and not to make an offer that's unacceptable to you. Some people, when they get into negotiations, start to feel really pressured to just, give up or offer something to the other side. And try to remember one thing in the negotiation is that sometimes the things that are important to you are not the same as things that are important to the other side. So probably the price might be important to both of you, but there might be other things. For example, if you're negotiating with a retailer, like advertising space or promotional offers or things like that, that may be easy for them to give you, and there may be things that are easy for you to offer to them regarding your timeline or volume or other things. So try to think what conditions are important to them and offer concessions on things that are important to them and less important to you. And also make sure that your concessions are always conditional, that you're offering them in exchange for something else. I will provide you the product in a faster timeline if you will lower the price by 5% or something like that. And if your concessions are not met, then withdraw your concession. So don't allow yourself to get drawn into a trap where you're offering and saying, I will lower the price on this item if you can have a faster timeline. And then 10 minutes later, the other person is talking like you offered to reduce the price, but they're no longer, changing the timeline. So be sure to think about that. And if the conditions aren't met, then withdraw your concession and make it clear that they need to be conditional. And stake out high ground by drawing attention to your concessions throughout the negotiation. The next slide, please. So again, remember your points and strategies during the negotiation. It's often helpful to bring some kind of sheet with you or to have it up on your computer. What are your points? What is your leverage? What makes your company important? Or the things you're offering important? What is your walkaway position? Think about your tone and demeanor during the negotiation. So setting a positive tone, I think that some of you mentioned that is really important in a negotiation, and that's true. And adopt a style that suits your temperament. It's important to remain calm and not to respond if the other party is engaging in outbursts. If they're slamming the table or yelling or shouting, just have a very calm demeanor and try not to react. I want you to type into the chat a negotiation style that you have or one that you think would be beneficial in a typical negotiation. So go ahead and type into the chat, you know, in 1 or 2 words, you know, what is your negotiation style? While you're doing that, I'll talk a little bit about information and leverage. I think this is so important. Ask questions and listen to answers. I'm going to say it again, ask questions and listen to answers. Use silence strategically to draw out answers and watch the other side's body language. You don't necessarily need to volunteer more information than necessary, but it's not always, you know, you also don't necessarily need to constantly hide things or seem like you're closed or you're not being transparent. So offer information strategically and know why you're saying something in the negotiation, but always ask questions and listen to answers. The more information you have about the other side, about what they want, about what they're interested in, the more information that you have from them across all of the things, the better deal that you'll probably be able to reach. And if the other side is not really offering information, but they're just sort of engaging in puffery, they're telling you lots of things without actually answering questions, don't be afraid to re-ask questions and to engage in that process first before you actually go into the meat of the deal. The next slide, please. Yeah, so I see one person said that they listen to what the other side needs and what they're going to offer before showing your cards. Yeah, that can be a good strategy to ask questions, as long as you don't seem like you're not being transparent, because that can be harmful in some situations. You know, things to avoid: last minute asks after the agreement reached. You know, there's really nothing worse than after you've been negotiating with someone and everyone's tired and feels good about the deal, for one person to say, oh, by the way, I actually just want to change these last 5 things really quick. You know, that's awkward. That doesn't leave a good impression. Last minute withdrawals, threats to walk out. You know, if the deal isn't going in your favor, and if you reach your walkaway point and the other side isn't being reasonable, they're not willing to negotiate, it's fine to say, you know, I don't think that this is a workable solution. I think we should step away from the table and perhaps, you know, communicate via email or rethink this. But threatening to walk out in, you know, an aggressive manner is not a helpful strategy. Don't be afraid to take breaks. You know, think about what you've accomplished, consult a business partner, your attorney, a financial advisor, or someone. Taking a break can also help to diffuse a tense situation. So if everyone's getting really uptight and tense, you know, it's fine to suggest that we take a coffee break or step away to consult a business partner. And finally, you know, you may give the other party time to rethink that particular situation. You can also de-escalate conflict during a negotiation. So try to understand the rationale for the other party's ask. Think about whether or not you can accommodate it some other way and make people feel heard. So one of my favorite stories around this, there's a really famous story of a negotiation that was taking place between a US company and a German company. And it was a small German company, and they were going to be supplying some raw goods to a US pharmaceutical company. And the US company had reached, you know, the negotiation had gone well. It was a deal that was clearly really favorable for the German company. And there was just one sticking point that everyone kept getting stuck on, which was that the German company refused to meet the US company's request to have exclusive use of the product. And this really was puzzling to them because they were going to be using it all. I mean, they could show demand. They were going to be using all of this particular raw product for, you know, for years and years. And there was not really any clear reason why they couldn't meet it. But the German company just refused and said, no, we can't do that. They would offer other things, but they couldn't give them exclusive rights to purchase it, the whole portion of that raw material. So the US company was entirely befuddled, and they finally went out and they hired a professional negotiator, a person who was really well known for being able to diffuse situations like this. And he came in and he sat down and he says, why? Why can't you grant us exclusive use? And the German company, the answer was that they had a cousin in another town who bought a very teeny percentage, you know, just a very small amount of that product every year to make something. And they'd had that relationship with their cousin forever, and it was a family-owned business, and it went on, and they didn't want to breach that agreement with their cousin. So by asking that question, why, they were able to carve out, you know, exclusive use except to this small, tiny amount that's getting sold to the cousin, and conclude the deal, which was really favorable to everyone. So sometimes just asking why, maybe think if you're hitting a point of contention, maybe you don't quite understand what the other party is up against, and try to think if you can ask different questions or accommodate their requests some other way. The next slide, please. And finally, memorialize your agreement. So nail down details, don't leave behind any ambiguities, and cover any contingencies. So think about things that could go wrong and address them. Define any words that might be unclear, or words that have an industry meaning but might be used in a meaning, in a way that's a little bit different than what you would otherwise think about. Define terms like close of business, for example. These are things that you can talk to an attorney about when you're getting some help doing the drafting or contract review, but make sure that these types of things are clear. So take notes during the negotiation. You can start by writing out a term sheet, and be sure to have that reviewed with your attorney, ideally before you actually sign it. If you write any handwritten changes, like you cross something out on a document, then be sure that it gets initialed by both parties. The next slide, please. All right, so that concludes our discussion on negotiation and contracts. I do want to open things up for any questions that you might have. So one thing that I would like you to go ahead and type in the chat box, I want you to tell me what part of negotiation you find the hardest. Is it prep? Is it de-escalating the conflict? So tell me what part of negotiation is the hardest to you and why. Any answers? Okay, so someone says that the hardest part of negotiation for them is ending the conversation. Okay, someone else said the price, actually negotiating the price. Yeah, that can be really hard. I think that our best advice to that often is to make sure you really have financial projections. So we do mock negotiations with our clients pretty regularly. And I had a negotiation where I ended up negotiating against my boss, who is an experienced litigator. And at the end of the deal, I thought I had kind of walked away from the table with a pretty good deal. But it turned out in the last probably 5 minutes of the negotiation, we had given away $30,000 on the table to the other side. And the reason that this happened is because my boss had a financial projection sheet up. And every time we changed even a cent on something, he was changing the numbers and repasting it to see, different offers, how they resulted financially for him. And it really makes a difference. So definitely work with the financial team. We have that resource at Start Small, Think Big, get projections, and be sure you're clear about the finances and bring that into the negotiation with you so that you're not just throwing out random numbers. The free market research, there's a question about where we can get free market research. You can contact the Rochester Library's Business Insight Center. And I can type that into the chat. All right, I don't see any more questions, so I'll let you have 1 more minute to type questions while we wrap things up. I want to say thank you so much to BOCnet and to SBA for hosting this event today, and thank you everyone for attending and for contributing to this workshop. It's always a lot more fun when people are interacting and participating, so thank you so much for that. I also want to thank my colleague Stephanie for her part of the presentation on contracts. We'll hang out for another minute or two so you can type questions if you have them. But otherwise, thank you so much for attending today. We will be sending out the slides and a negotiation tip sheet for you.
Thank you, Elizabeth.
Thank you, everyone.
Thank you, everyone. Okay, so
thank you for a great presentation. Stay safe and be well.
Okay.
All right, I see a question from Maria. Is there such a thing as a group coaching contract? You can have a contract for just about anything, quite honestly. If you have a question about, how to write up a group coaching contract, or if that's the best solution for your situation, then I encourage you to reach out to Start Small, Think Big, via our website. You can request services there.
Any more questions? Yes, no.
All right, thank you so much. It was
Okay.
great.
Thank you. Have a good day, everyone.